Welcome to this podcast. My name is Abboud. This is a two-part series on introducing private acquisitions. So what we're talking about here is the acquisition by a private company of a target. The target can either be another company, another private company, or the assets of another company. So obviously by private company, we mean a private company limited by shares, and usually it'll have the words limited or LTD at the end. The company or a person is the buyer, and they buy the target from the seller. And again, that can be a person or a company, but usually we deal with companies. In terms of what the target should be, the target can either be you're purchasing 100% of the shares of another belonging to one or more sellers, or assets, property owned by the seller. That could be a factory, that could be a warehouse, that could be a mixture of assets, including, of course, intangible assets such as intellectual property. And for the purposes of the discussion, sometimes I'll refer to owners, sometimes I'll refer to shareholders, just to mix it up. They both mean the same thing. So essentially, what we're talking about here is a private company buying either the assets of another company or part of the assets, usually of another company, or buying all the shares of another company. This is done in one of two ways. By private treaty means that the buyer and the seller will be in negotiations with each other, and they will just conclude an agreement, a purchase agreement between them. And they're only in discussion with each other. So usually these discussions are done under conditions of exclusivity, meaning that the buyer can only negotiate with one seller and the seller can only negotiate with that buyer for a period of time. The second way, you can buy assets or all the shares in a company, is by an auction process. So someone knows that they want to sell part of their business or part of their assets. They'll basically put together some kind of brochure, prospectus, and potential buyers will then put in bids. So it's an auction process, basically. So what is the purpose of an acquisition? Well, the purpose of an acquisition is to expand the business. So looking at it from the perspective of the buyer. From their perspective, their aim is to somehow expand what they're doing. Now that could be domestic expansion, so they buy the assets or a company domestically in the UK, or this could be a way of expanding internationally by buying the assets or a company based abroad. Now, in terms of how this fits in, how an acquisition fits into all the other types of commercial agreements that are out there, the acquisition is the most definitive kind of agreement you can get into, because it's essentially very difficult and very costly to unwind. So at one extreme you have an acquisition. At the other extreme, on the left hand side, you have a agreement in the ordinary course of business, so like a supply agreement or a distribution agreement. So just agreements that companies enter into every day. Sort of in the middle, you have some kind of, doesn't have to be international, but it could be any kind of collaboration. And the difference between collaboration and a normal agreement in the ordinary course of business is that collaboration involves usually some kind of cooperative joint decision making. And most often you'll hear this kind of thing referred to as a joint venture. There's no kind of legal definition in the UK as to what a joint venture is. It's just a commercial term, and we usually mean some kind of collaboration that involves joint decision making. So a good example of that would be two car companies deciding to collaborate to develop a new type of car or a better type of car. That involves some joint decision making. It means they've got to choose a technology, they've got to choose the different, the research and development has to be done together, perhaps the production has to be done, at least coordinated, and so on and so forth. So that's not an ordinary agreement. That's just a supply agreement, a repair agreement, a maintenance agreement, a distribution agreement, an agency agreement. This involves some actual joint cooperation. Now, an acquisition is a step up from that. It's definitive. It means that one company is taking over some of the activities of another and using that as a way to grow or to develop or to refocus its activities. So, the purpose of the previous slide was just to show you how an acquisition fits in to everything else. And you'll see, and I think the main takeaway from that was that it's a big decision. It's usually the most important decision a company will take for many years, because it's the one that is most difficult to unwind. Once you've bought significant assets or bought a significant company, the only way really to get rid of it is to again go through the same process, this time being the seller. So because of that, it's really important that the buyer does what we call due diligence, which is another way of saying doing their homework about the target that they're buying. And really the whole process of private acquisition is about that due diligence process, the process by which the buyer asks questions of the seller about the target they're buying, gets answers, and then puts some of those answers or most of those answers into a purchase agreement. That's really the whole point of all of this. So in order to get there, there's a series of steps that are usually taken. So as I say, the focus of this is what we call private acquisitions, as opposed to the acquisition of a public listed company. Due diligence is still done in the process of public acquisition, but there are different regulatory issues there that we don't need to concern ourselves with. First thing that happens is the parties begin to negotiate. And here I'm talking about, not an auction scenario. We'll deal with auctions later. But you've got two companies that have identified each other as the buyer and the seller. And that could happen in a number of ways. A buyer might approach a potential seller and say, listen, we've heard through the grapevine, you're no longer interested in this bit of your business or this subsidiary. And actually it fits what we want to do. So, if you're in principle happy to start negotiating, we could do so. Or it could be the other way around. A seller is thinking of getting rid of a company or some significant assets, and they have in mind a competitor or someone else who might want to buy it. Quite often this is done by, the idea is done by bankers or consultants who are advisors to, say, the buyer or the seller. And because of their industry knowledge, and they know what they've got the finger on the pulse, they can identify potential partners, and then they can make an approach to both sides, essentially acting as middle people, if you like. And then that's how the idea will develop. And at some point, if the idea that this seller should sell to this buyer, then they'll enter into negotiations. And that's really the point at which lawyers and accountants come in. One of the most common things that then happens once negotiations have been going on for a decent length of time, and what a decent length of time is just differs deal by deal, but say something like a month or two, is that the parties will sign something called, well, it can be called one of three things: letter of intent, memorandum of understanding, or heads of terms, and they usually mean the same thing. And I'll talk more about each one of these in the coming slides. They then sign a confidentiality agreement, and then they have to decide how they're going to structure the deal. So quite often there is a choice between doing this as buying the whole company or buying a significant part of the assets of a company. And again, we'll talk about why you do one rather than the other. As you're doing that, you then send off what's known as a due diligence questionnaire, which is a set of questions the buyer sends to the seller about the target. And there's all the important information they want. It's pretty much like how you decided you wanted to do a university course in law in a particular law school. You did your due diligence in a way. You looked at rankings, you talked to people who'd been involved there, you perhaps asked questions of the recruitment team, you perhaps asked questions of the admissions tutors. So it's no different to that. Because it's such an important process, you ask a huge number of questions across all the activities of the company. Again, more on that later. You then get the answers back from the sellers about the questions that you've asked, and you take those answers and you may put some of them as binding promises about the target in a purchase agreement. So if, for example, they say that the factory that we own in this address is owned fully by us, then that is a promise that you would put into the contract. Because if it turns out to be wrong, you then want a basis on which to sue the other side. As you're doing that, you're still thinking, sometimes you do this due diligence process, and initially you thought, I'm going to buy the whole company. You're going to do a share, or what we call a share sale. That means you buy the whole company. Turns out that company, from the due diligence you do, has a huge amount of liability. So it's got debts to banks and debts to, say, HMRC and debts to suppliers, say. And you go, no, I'm not taking on that liability. Instead, what I'm going to do is I'm going to buy some of the assets. Now, again, the seller might resist that because they don't want to be left with just liabilities. But if they're a big group and they have loads of subsidiaries, they might be willing to do that. So the issue of whether to structure this deal as a share sale or an asset sale, usually you take a view at the beginning, but maybe as the due diligence process goes on, you decide to structure the transaction differently. Now, whatever you put in the purchase agreement is enforceable. It's a contract. It's usually enforced by going to arbitration. So it's a secret process, and usually the judgment, the arbitral award, isn't published, so you can keep everything confidential. But certainly, it's a really important issue, which I'll touch on in a bit. So, what I propose to do is to, in this podcast, talk about the initial stages and then focus more on the due diligence and the fruits of due diligence. The whole negotiating the purchase agreement in the second podcast. Now, the first thing is, after we've been negotiating for a few months or a few weeks, if things are going well, you would sign a letter of intent or an MOU or heads of terms. They all mean the same thing. What this contains is the points that the parties have already agreed and a roadmap about the other issues that remain to be agreed. The rationale for this, now this isn't a legal requirement, this is just commercial practice, and for an acquisition, it tends to be done, especially for large acquisitions. And the rationale for this is to just give people a roadmap for what has been agreed and what hasn't been agreed, and almost like a moral obligation not to go back on what they've already agreed. Now, this document should have a clause in it that says this agreement is governed by English law. The reason being that this would make the agreement non-binding. Other jurisdictions take a different view. So the reason this is non-binding is it's an agreement to agree, which in English law does not have binding force. So you need to have all the terms, or most of the terms of a contract clear for it to be binding. So you want to make that explicitly clear if you don't want this to be binding. And most commercially minded, companies don't want it to be binding because they want the flexibility of, if they discover something down the line in due diligence, to change their mind about what has been agreed. So that's an important point. Other jurisdictions make most agreements subject to something called the principle of good faith, which in the French tradition and say the German tradition and the Italian sort of civil law tradition is legally binding. And there's almost an obligation on them to reach an agreement. And if one party is unreasonable in not reaching an agreement, then they can be sued for damages. Now, in English law, we don't have that. So a lot of international transactions, so by that I mean involving a buyer and a seller from different countries, sometimes will have their agreement subject to English law to allow for that kind of flexibility. So first thing that could happen after negotiations have reached a kind of decent stage is that parties put down in a non-binding way what they have so far agreed and what remains to be agreed. Another initial consideration, and as I said, this continues as you do due diligence and learn more about the target, is whether you're going to buy property. So you're going to buy the factory, the warehouses, the IP. Are you going to cherry pick those? You're going to buy, say, the seller has 7 factories. You may think, right, I only need 2 of those factories. And I need the warehouses, some of the warehouses. I need some of the forklifts. I need some of the IP. So if that's all you're after, and those may be worth hundreds of millions, well, you'll structure the deal as an asset sale. So you buy property, primarily land and other. So real assets means land, and then other assets such as chattels like stock and cars and trucks and lorries and so on. Or you can buy the whole company, in which case all the assets of the company come with it. But then the downside is all the liabilities also come with it. So again, I'll say a few more words about that later on in the podcast. But essentially, if you buy an asset, you don't get the liability. So say a factory produced goods that killed people and people sued the company for negligence. If you buy the asset, you don't get the liability of that going, for the past issues, because the liability is linked to the company. It's the whole idea of separate legal personality. The company has a personality of its own. It's not linked to its assets. So if you buy from X, or if X is the manufacturer, in typical Donahue and Stevenson scenario, you will sue that manufacturer. Doesn't matter who controls or now owns the factory that did the deed. So an asset sale has the massive advantage, or 2 massive advantages, of being able to cherry pick which assets you want from the seller, and B, you're able to take the assets free of any liability that company has. The downside of an asset sale, the downside of saying, well, I want this factory and that lorry and whatever, is that you have to make sure in the negotiations that you identify all the other assets that are needed to make this happen and the contracts that are needed to maintain those particular assets. So I'm thinking of stuff like if you're going to buy a factory and you want it to continue doing what it's already doing, you also want to get the benefit of any contracts for supplying parts and raw materials. You might also want to get the contracts for selling the products, so the purchase agreements or the distribution agreements. On the other hand, if you're just buying the assets because you want to turn it into something different, then you don't care about those contracts. But you may care, say, about the maintenance contract for the factory. And the big issue is, of course, workers. So in an asset sale of a place where people work, there is something called the 2P regulations, which relate to transfer of undertakings, whereby there are provisions that allow the workers, that oblige you, the buyer, to allow the people who work there to carry on working there, subject to some exceptions. So that's kind of two plus points and a couple of downsides, which is the downsides being you got to identify all the assets that come with the assets you want, including any contracts, which is an intangible asset, if you like. And you've got to navigate the 2P regulations, which deal with the transfer of people where you're buying an asset where people work. So if I buy a factory, well, that's where people work. You've got to follow the 2P regulations, and that gives people certain rights when their place of work has been transferred. A share sale, on the other hand, for the buyer has a downside, which is that you get all the liabilities. So you've got to make sure you identify very clearly all the liabilities that are going to happen and know what they are and be able to quantify them, in which case a share sale can be a very good thing because you get everything. You get the assets, you're not worried about have I got all the assets I need. It's quite a simple thing. And for the seller, it's a clean break. They're not messing around with selling some assets and not others. So that's an issue that will be thought of at the beginning, but will also be considered as the deal progresses and as the buyer gets more and more information about the target. So at the same time as signing a letter of intent, there is usually, in the letter of intent actually, there's usually an obligation to sign a confidentiality agreement. And then there is a separate confidentiality agreement, which we call an NDA usually, which means non-disclosure agreement, otherwise known as a confidentiality agreement. So why would the parties want to negotiate under confidentiality? Number of reasons. Firstly, they're giving each other business secrets. In order to have a useful negotiation, you've got to tell each other things about what you want to do and things about the target. So that's sensitive information. And there's a competition law aspect to that, which is that companies who are competitors and are trading business secrets have to limit that to certain key people and have sort of Chinese walls in place. So not everyone in the business just gets to know about a competitor and then they can stop the negotiations and essentially collude, create a cartel. So that's one important reason. The other important reason is obviously this is important information in itself, which both sides will want to make sure doesn't get out beyond the two companies negotiating. Final thing I should have said, actually, in the context of a letter of intent is letter of intent has usually 3 binding provisions. Although the whole of it is non-binding, it'll say this document is non-binding subject to 3 clauses. The first is the choice of law. So it'll say this is governed by English law. Second clause is the obligation to enter into a confidentiality agreement. And what usually happens is you put a draft of the confidentiality agreement in an appendix, and then that gets signed at a later stage. If not, you sign it at the same time, in which case you don't need that provision. The third point is an obligation to negotiate exclusively with each other for a period of time. So that's an obligation of exclusivity. So both sides, seller and the buyer, will say, we will negotiate exclusively for the purposes of selling this business for a period of whatever it is. And that's up for negotiation. So those 3 provisions have to be binding. Now, we come to the due diligence process, which I said was no different to any kind of important decision an individual has to make. Like going to university, taking a particular course, deciding on a career. It's very much a case of asking questions and seeking information and then coming to a decision. There is a common law principle at play in contract law, which is caveat emptor, buyer beware. In other words, if the buyer hasn't asked particular questions, they then can't sue the seller if things don't turn out the way they wanted to. So if you haven't asked them how many accidents have there been in the factory and has anyone sued you, when you buy the factory and then it turns out the factory procedures are a complete shambles and people are now beginning to sue you left, right and centre because you're producing faulty goods, you can't then turn round to the seller and say, hey, you sold me a dud asset, essentially. On the other hand, obviously the seller cannot mislead the buyer, but the seller could just stay stumm and not say anything. But we get over that very easily by having a process whereby the buyer asks the seller a large number of questions about the target, including asking to see key documents and key contracts. Again, this isn't legal obligation, there's no statute or common law rule that says the buyer must ask these questions and these are the questions that must be asked. But this has just come out of commercial practice, and this is done pretty much anywhere in the world. This is a standard technique, whether you're in England, in Scotland, Nigeria, Egypt, South America, it's the same process. So there may be in certain civil law countries more buyer-friendly implied terms into contracts, but you just make your life easier by asking a large number of questions. And law firms have built up a bank of questions that are relevant for each industry that they deal with. Like renewable energy, there'll be a set type of questions that are asked that are specific to renewable energy. Buyers will always ask certain questions no matter what the industry is, but there'll always be some industry specific ones. So law firms will have their own lists. There are 2 databases that law firms sometimes use, especially smaller ones, but also the larger ones use them, Practical Law and PSL, who have precedents that can be used and adapted. So what happens what stops a seller from answering these incorrectly? Well, when the buyer sends off the due diligence questionnaire and the questionnaire comes back, it may be, and quite often has, some inaccuracies in it. However, minds get concentrated at the next stage. The next stage is you take some of those answers and you may put certain certain of those information as binding promises of some shape, which we'll discuss, into the purchase agreement. So say you're buying a whole company. You want to know what assets there are there. So you'll get them to tell you in the due diligence process, in the questionnaire, what their assets are. So tell me how many lorries you have, tell me how many factories you have, tell me how many workers you have, and in a huge amount of detail. You then put those into the contract and say, I promise that as of this date, I have the following employees, I have the following vehicles, I have the following contracts worth over £20,000 or whatever it is. And that tends to concentrate the minds, because when you then draft that initial agreement and ping it over to the other side, to the seller will usually look at those and then send them off to people in the company. And then they'll go, all right, this is serious now. This is going to be a binding contract. So I have to correct what I perhaps accidentally got wrong, or in some cases deliberately got wrong. And the negotiation of the contract is a way of getting even more information, because it really does concentrate people's minds. They know this is going to be a binding contract soon. So just to make the point, this is no different to personal due diligence. When you rent a flat, you buy a car, you decide to do law, and so on and so forth. So this is a process that actually can be done for the most important contracts a company can get into, not just an acquisition, but an acquisition is where you do the most extensive due diligence. It just to give you some perspective, it's also useful if you're going into a very complicated joint venture with another company and you're committing to partnering them for a certain period of time. You will do due diligence on each other to check what each side claims to bring to the table. So again, in my example of the two companies who are going to cooperate to produce a new type of car, say one has excellent research facilities and the other has very strong workforce, you might want to check that and ask questions about the workforce, ask to see their CVs perhaps, ask to see their remuneration, ask to see their terms of employment. So, key people, you want to know how quickly they could leave if they gave notice. On the other side, you want to know about the ownership of those facilities, the performance of those facilities, and so on and so forth. So due diligence is an important process in the commercial world generally. And the more important a contract that you're about to enter into, the more important the due diligence process will be. And as I said at the beginning, acquisitions are extremely difficult to unwind. So you want to make sure you get as good a picture as you can of that process. There's legal due diligence, which is what we as lawyers do, but there's going up that 3 bullet points, there's technical due diligence. So people who are experts at, say, analysing an IT system, they'll go in, and if the IT system is really important for the buyer, they'll send in IT consultants to check out the IT systems. And there's also tax and accounting due diligence, which is done by auditors mainly, as well as lawyers, to understand the tax position and the performance, the accounting performance of a company, especially when you're buying a share sale, in the share sale where you're buying the whole company. But tax is useful in all situations, really. So the coverage of legal due diligence is basically every single department of a law firm, every practice area will be involved. As they says there at the end, all involved, but focus differs depending on the industry. So if you're buying, say, um, a piece of land, a farm, then the IP people aren't going to be doing very much unless there's a brand involved, or a logo, or some kind of copyright to do with brochures and so on. But you'd expect the real estate team to be extremely important to that deal. If the land is structured as a company, obviously the company people will be involved. Health and safety, employment is always involved, of course. Finance is involved if we're dealing with any kind of debt, and all the other ones will be as well. So that's an example. Contrary example would be a biotech company buying another biotech company. So those tend to rely on patents quite heavily. So here, in contrast, the IP people will be extremely busy with that kind of transaction, but everyone else will get involved as well, and especially retail and finance, real estate and finance, for example. So the reason you should know about this process is that it doesn't really matter which department you decide to do. You could decide to become an employment lawyer. You can decide to become a competition lawyer, or a tax lawyer, or an IP lawyer, or a property lawyer. In larger commercial corporate law firms, you will get involved in merger work, and sometimes it's called corporate support. Sometimes they just say it's merger work. But you will be involved in that process, and everything is coordinated, usually, depending on the law firm, but usually by a corporate partner, and he or she is usually the person who has the relationship. It may be different if we're dealing with land and it's a large farm or a small farm, and the client contact is usually the real estate team. They're the ones who will perhaps lead it, but the company corporate lawyers are the ones who have a lot of experience of integrating all this advice from the different sub-teams. So it's something that you will get involved in if you decide to go into even a medium-sized corporate law firm. An acquisition can be an acquisition of anything, a business worth £200,000 up to a business worth £200 billion. So the process is pretty much the same, irrespective of the size of the transaction. So we've talked about due diligence as being doing your homework about the target, but let's be more specific. The aims are, firstly, to assess the value of the target. You get all this information about the state of their factories, say, of their trucks, of their personnel, of their senior management team, of their liabilities, of who owns, what type of ownership they have. Is it a leasehold? Is it a freehold? Are there mortgages over it? Are there rights of way in relation to all this thing? You're doing this to help value the target. That is the most important thing. Close second is you want to put contractual mitigations into the purchase agreement. And these are usually known as warranties. So they're promises about a state of affairs. So I promise that this company has 4 factories. This is their address. This is who owns. This is the status of them in terms of freehold or leasehold, and so on and so forth. The third thing is it allows the buyer to start thinking about how to integrate the target into its business. So these are the 3 aims. The contractual mitigations, the middle point, isn't just warranties, it's other things as well, which I'll talk about a bit more in the second podcast. So I'll leave it at that. The next podcast will look at the purchase contract in more detail. What do we do with the fruits of due diligence? So once we get back the due diligence questionnaire filled out, hopefully in full, but not always. Sometimes there's missing information. What do we do with that information? How do we then put it into a binding agreement, a purchase agreement? and how do we mitigate risk generally. And that's really the purpose of the second podcast, which I hope you listen to. Thank you very much.